certainly already the Indian position on public stockholding of food has exposed it to trade disputes with the U.S. and many other countries, because we saw those disputes soon after the Food Security Act was passed in this country, and then we saw in the months preceding the December 2013 Bali ministerial meeting a number of concerns raised by other WTO members about the implications of that act. So the first answer to your question is an easy one. Yes, there have been disputes. And that I might then right away say is as a practice tip for international trade lawyers and policymakers to head off disputes in advance, solve problems before they arise, suggests that maybe writing these food bills, agriculture bills, or bills in any event that affect international trade law might be done with a view to what the reaction will be from other WTO members, including possibly consulting with other WTO members during the legislative drafting process. The second part of your question is, has India actually breached any WTO rules as of yet? Well, thanks to the December 2013 decision that was taken at the Bali ministerial meeting on public food stockpiling, the answer appears to be no, at least under the agriculture agreement of the WTO, and at least until 2017. But the answer is uncertain under the WTO Subsidies and Countervailing Measures Agreement. To explain that answer a little bit, there was a lot of concern among some of India's trading partners that maybe the Food Security Bill had indeed already violated WTO commitments because it was creating subsidies that were not properly authorized in the green box, and that was then of the agriculture agreement, and also might have been subsidies under the SCM agreement. Well, thanks to the December decision in Bali that the trade ministers took, they agreed to defer, at least till 2017, any permanent solution, and in the next 4 years work towards a permanent solution. Also during those 4 years, until 2017, the trade ministers agreed that they would, in effect, immunize existing public food security programs, not necessarily new ones, but existing ones, from suit under the agriculture agreement. They did not extend that immunity necessarily to the SCM agreement, and they did not extend it to subsidy schemes that are outside of public food stockpiling programs. So maybe to summarize the point, there's some breathing space for trade lawyers and trade negotiators to reach a long-term solution, and hopefully they'll do so before 2017. And then go forward, my own personal suggestion might be to work with trading partners during the legislative drafting process to avoid these issues in the future. What's happening is a concern that maybe there are illegal subsidies, or perhaps there are illegal domestic content rule requirements under GATT WTO or SCM agreement rules. That is to say, maybe the legislation that India is drafting or has drafted on solar panels or other topics might breach GATT Article 3 rules on national treatment and domestic sourcing, or maybe they might breach rules under the Subsidies and Countervailing Measures Agreement. Now, I think to put this in context, without commenting specifically on the solar panel dispute, These sorts of trade remedy cases, anti-dumping or AD and countervailing duty or CVD disputes, are to be expected in a normal, healthy, flourishing trade relationship. It's important not to overdraw an adverse inference and suggest that one case or even a few cases is the start of a trade war. That's not correct. It's normal that countries like the US and India in a burgeoning trade relationship are going to have disputes about whether one side is dumping or subsidizing or having impermissible sourcing rules. Now, when we come to this particular dispute, one suggestion I might have is for the Indian side to look around the world, not just at what the U.S. officials are doing, but around the world at what trade authorities are doing with respect to exports from China. Because, as we know, China entered the WTO in December of 2001, and ever since it did, there have been a large number of Chinese products coming in to countries around the world. China has been an export platform for the world's multinational manufacturers, and countries as diverse as Canada, South Africa, the United States, the European Union have taken trade remedy actions, AD/CVD actions, and also safeguard actions against Chinese products. Well, India, as the world's largest free market democracy and soon to be the world's most populous nation, is enjoying a healthy boom, or hopes to enjoy a healthy boom in its exports. So tracking what cases have been brought against Chinese merchandise may be a harbinger, maybe gives some insight into what officials in other nations might do should there be similar trade patterns from India. To be sure, India is not a non-market economy. It's not an NME, so it's not going to be treated under non-market economy rules. But there are issues that have affected trade between the U.S. and China and other countries. Rules, for example, about double counting of subsidies and countervailing duties, or rules about causation standards. When can authorities say that subject merchandise from China has actually caused injury to a domestic producer of a like product? Well, those disputes have produced a growing body of jurisprudence in the U.S. and other countries, and it would behoove Indian trade lawyers to take a look at that jurisprudence and see what lessons might be gleaned, again with a view to avoiding future trade disputes. I want to be careful not to comment particularly on the solar power case because frankly, I've not seen the litigation papers filed by both sides. To my knowledge, they may not have been made public yet. Eventually, they may appear on the website of the WTO or through other websites. So it's difficult for me to comment on facts of which I'm not familiar. But your broader question is one that I can try and address, and that is about the issue of the quality of the products. And I think here I would stress the shared interest that the U.S. and India have in high-quality products, whether it's solar panels or whether it's intellectual property products like patented pharmaceuticals or generic pharmaceuticals. One of the worst things that can happen to a producer-exporter is that it gets a reputation in the importing country of having high-cost products, or even worse, low-quality, dangerous products. Now, we've seen over the last several years that sort of reputation develop in the U.S. market among many U.S. consumers with respect to Chinese products. There's been a concern because of a number of unfortunate incidents in China where product safety, product quality has not been to the standard that is expected in the U.S. By U.S. authorities and by consumers. well, those products, of course, are not going to be purchased by consumers. Moms and dads naturally want to protect their kids from bad food products, as indeed they would in the home market in China. So similarly, when it comes to solar panels, questions of whether or not the carbon footprint of the panel is sufficient, or whether or not it's got too much of an environmentally unfriendly ingredient in it. Those are natural questions for importing countries to ask. But I think another point to understand here is not only the shared interest in high quality products, but also the sovereignty that exists among importing countries, among all WTO members, that they have the sovereign right under the WTO agreement and all of its annexed accords to decide what the product safety standards should be, as long as they're not unjustifiable barriers to trade, as long as they're reasonable measures, as long as they are not administered in a discriminatory manner. Countries, U.S. or India, have that sovereign right to protect, not be protectionist, but to protect their consumers in a way that they and their elected officials deem appropriate. It's certainly fair from the perspective of the U.S. trade representative, and it's certainly not fair from the perspective of the affected Indian companies. So the fairness is a little bit depending on which side you ask, but let me try and explain a little bit the legalities of what's going on and a little bit about both sides' views on the matter. First, what happens under U.S. trade law, under what we call Special 301 of the Trade Act of 1974. It actually is a provision that was added later on in 1988. But under Special 301, countries are identified annually by the U.S. Trade Representative for the extent to which they enforce intellectual property rights, patents, trademarks, copyrights, semiconductor mask works. Countries that are of concern to U.S. authorities, and thus they would be of concern to them because of the underlying producers of the IP products from the U.S. that are selling into those foreign markets. Countries of concern are put on a category, one of three categories. And the watch list is a simple category. It's the lowest level of concern, but it's still some country to watch what it's doing. It's a little bit of a notice that the USTR is watching what's occurring in that country and is taking matters a little more seriously because there are some concerns that have been identified. There's a moderate level category, and then there's the priority list, the highest level category, which India is on or may be on. And the concern there of being in the most serious blacklisted category, if you will, is that if the dispute cannot be solved by the trade negotiators, that is to say, if the Indian and the American side cannot come to an agreement on adequate enforcement of intellectual property rights in India that are allegedly being infringed by India, alleged by the United States, then a Section 301 investigation is triggered. And in that case, what the U.S. Trade Representative is going to do is take a very hard look at the acts, policies, or practices of India to see whether or not they are indeed violating any intellectual property right under a trade agreement that the U.S. and India are party to. Now, the obvious trade agreement that they're both party to would be the WTO TRIPS agreement, trade-related intellectual aspects of intellectual property rights. And the USTR would take a hard look and say, look, we've not been able to come to a diplomatic resolution of this matter. We still think there are violations for example, of the Article 31 as amended compulsory licensing rule under TRIPS, or the evergreening dispute on patents. And we're going to take a look at that under TRIPS, and we're going to see for ourselves whether or not we think there's a WTO case to be brought. I've not studied the Indian decisions, so I have to be careful not to comment on decisions that I've not studied yet. Also, I want to be careful that much of the substantive nature of what I understand those decisions to be concerns patent law. And that's especially the area, of course, that is different from my own. So I don't want to venture too far out of my own area and talk about whether or not it was legitimate to grant that compulsory license for the patent, and likewise whether or not the evergreening issue is a fair one according to the Indian officials. But look, the more general point is well taken. It's very frequent that a WTO case arises out of a judgment from a domestic adjudicatory body, like the courts you've mentioned in India, or like the Patent Appeal Board in India. And the foreign government involved in that decision or affected by that decision says, look here, we disagree with the outcome in the domestic court or in the domestic administrative tribunal. And that is what gives rise, that's what catalyzes the WTO case. So simply because a domestic court or a domestic administrative tribunal says what we have done under our local law complies with WTO standards is not the end of the matter. It's going to be ultimately for the WTO appellate body to decide whether or not the Indian bodies actually did act consistently with the WTO agreement. And to be reciprocal, this is the same thing that happens in the U.S. It's very frequent that the Department of Commerce or other U.S. agencies involved in international trade will take a decision that may get appealed in our domestic court system to our Court of International Trade or our Court of Appeals for the Federal Circuit, and the foreign parties involved and the foreign governments involved do not agree with the outcome in the U.S. They think that the U.S. authorities somehow managed to get it wrong and it's WTO inconsistent, so they take the issue to the WTO appellate body. And that's the beauty of having an appellate body, a panel first and then an appellate body second, that we have a neutral body of experts who are not representing either the U.S. or India, not representing any particular country, but are there meritocratically to come to the best possible outcome. Well, what would happen next is, what would hopefully happen next is the U.S. and Indian authorities would agree on, in effect, an action plan whereby India would enforce to the satisfaction of the U.S. side, and the U.S. side would make compromises to the satisfaction of the Indian side on intellectual property rights. And in that case, India would be would be taken down a notch or even 2 notches. It would go to a lower level listing and possibly even drop off the listing entirely at some point. That's the hoped for outcome. And in fact, that's the nice aspect of the Special 301. It doesn't result in litigation right away. It is, albeit with some threat of litigation, it gives the 2 sides notice that we need to talk seriously now. Now, if that doesn't happen, then a Section 301 investigation can be launched by the U.S. Trade Representative. And there the U.S. Trade Representative will take an assessment as to whether or not the Indian decisions and the Indian acts, policies, or practices violated the TRIPS agreement. If the USTR finds that they did not, end of case. But if the U.S. Trade Representative finds that they did, then it's quite likely to blossom into a WTO action where the United States would take action against India under the WTO. And there again, under WTO dispute settlement procedures, there would be a period for diplomatic settlement, roughly 60 days from the date of bringing the case. The two sides, India and the U.S., would consult during this consultation phase, hopefully resolve the matter. If it's not resolved, then the case would be assigned to an ad hoc panel of 3 WTO experts, that is, experts who are from any of the WTO members would be assigned the case. They would take oral and written arguments, briefs, that is, and then oral arguments in Geneva, and the panel would issue a report. Usually that report comes out within 9 to 12 months of the initiation of the WTO action. If both sides are satisfied with that panel outcome, then neither would appeal. And both sides will have an opportunity to look at the panel outcome because they will be circulated a confidential draft panel decision. Now, if neither side or either side is satisfied with the outcome of the panel report, then either side or both sides could appeal the case to the WTO appellate body. In that case, 3 of the 7 standing member appellate body members, I should say, would adjudicate the case, and they would take roughly 6 to 9 months to do so. So the total time frame to resolve this case would be approximately 12 to 18 months, assuming there's appeal. Then let's suppose, hypothetically, India wins the case. The U.S. does not hypothetically prove its claim of, say, TRIPS violation allegations. End of case. The two sides go home. Let's suppose, on the other hand, that India does not successfully defend all of the claims brought by the U.S. In that case, the appellate body is going to offer a generic recommendation that India bring its IP measures into conformity with its WTO obligations. The appellate body is not going to specifically tell India what to do in terms of amend this section or amend that section or change this policy or revoke this decision. It's going to leave it to the sovereign province of the Indian officials to decide how best to comply with the appellate body recommendations. Usually the losing side in a case at the WTO is given a reasonable period of time, an RPT for compliance, and that period is typically 15 months. So now we're looking at 15 months after the final outcome from the appellate body that's been adopted by the WTO. So if you add all those months together, you're looking at 18 months for an adopted appellate body report, plus 15 months for a reasonable period RPT of compliance, a total of about 3 years. So within that 3-year period, or in the latter part of it, then the U.S. and other WTO members would expect India to bring its offending measure, if it has been deemed, again, offending, into conformity with WTO obligations. Now, we've seen those kinds of cases in IP before. In fact, the very first TRIPS case emerged from the so-called mailbox rule, and that involved a case involving India as the respondent, as the defendant in the case. So we've seen such cases before. And again, this is part of the normal, healthy trade relationship that's governed by the rule of law.